Hey everybody, welcome to what is going to be a big day. I gotta check everything. I bumped my camera just as I was going live here. Thank you for joining this live stream here. We're going to cover the Kyle Rittenhouse closing arguments. For those who may not have seen my mentions of this in other videos, today's going to be well, has the potential to be a kind of long day. So with that said, if you bounce back in and out, totally understand. I might have to do the same as well. I got a family to run, so if something goes bump or somebody knocks on the door, I will obviously have to step away from the screen, but I will be right back. So the judge has allotted each side, the prosecution and the defense, 2 hours each to make their closing argument, and then a 30-minute rebuttal. They don't have to use their whole allotted time. The prosecution typically does. But we'll see how it goes. I will have it all here. Again, if I have to step away, understand, please, that I have a lot going on here with children and just get back from a trip. So there's a lot going on in the house, and everybody who has a family gets that. So I just appreciate a little courtesy on that end. But I will be here through the whole thing. And I'm just waiting for the stream to start from the courthouse. It's scheduled to be, well, the courthouse opens at 10 Eastern, which is 9 Central out in Wisconsin, and we'll put it on as soon as it goes live. Today's live stream is thankfully it's supported by Blackout Coffee. Today's Monday. It's the Monday morning grind. blackoutcoffee.com/GNG. I am a part owner, so by using my link, blackoutcoffee.com/GNG, you directly support Guns and Gadgets. Blackout Coffee is a huge supporter of the channel, which is why I decided to become a part owner. So I appreciate the support. I'm going to do my best to try to keep up with the chat. You guys know that I suck at keeping up with the chat because there's a lot going on for one person and other people. I'm a hyper-focused kind of guy. I'm not a 55 things at once. So let's go to the chat and see what's here. We have about 9 minutes before the court opens up, and the feed hopefully will start right away. Well, we'll put this one up. Let's see. Can I get it on? Work. Go. All right. I guess I got to try it on this side. All right. Lamont Russ promoting another channel. Ricada Law. There's a lot of people putting it up. But if you support Guns and Gadgets, stay here. Doesn't matter who the hell covers it, as long as it gets covered in airtime. Lamont, if you want to go over there, thanks for stopping by. I appreciate the super chat. I'm not here to poo-poo on any other channel. I think everybody who's been a member of this group here for any amount of time knows that. Support those who support you. Let's see. My intent for those who did put a super chat is not to miss them. I apologize. Some were made before we came live. 2A says we should take a leaf out of the leftist book and try to get this profoundly corrupt DA disbarred. I know there was a petition to do that, but I mean, I don't know about you all, but I think petitions are. I'm not a big fan of petitions because I haven't seen one that's really worked in the last, I don't know, couple of years. Which, not to poo-poo on them, they can get stuff done when you do it for a referendum to put things on a ballot. That's fine, but as far as like a political action or something like that, I haven't seen them be effective. Dwayne says, I do have to say the judge in this case has done a great job to this point. Yeah, he really has. I know there's those who are against what's going on with Kyle and stuff. They think that this judge isn't doing a good job, but he's done a solid job for an area in the country that isn't known for getting huge attention on cases, right? I do have one from Sean G that for whatever reason isn't going on the screen. He says, freedom isn't free. Keep doing what you're doing and inform us about keeping our freedom. Let's go, Brandon. Yeah, man, appreciate it. It's an interesting time, to be sure. I'm going to, hopefully I didn't lose you. We just had a power surge. Let me know if you all are still here. It looks like we are. I just heard, I think I just blew my speaker out. The power surge. Great. Awesome. Thank you, Lee. Thank you very much. Appreciate the support, guys. Mark says, keep us free. Long live the Second Amendment. Free Kyle, 100%. Humanity is epidemic, not guilty. Now, I want to address what people can expect today. We got about 7 minutes before they go on, hopefully. So today, like I said, it's closing arguments and then rebuttals, and then it'll be put into the hands of the jury. And there is no telling how long the jury will consider the case. It could be quick, could be drawn out. We've all seen cases that the jury comes back very fast when the evidence is overwhelming. And I do believe that the evidence is extremely overwhelming in this case, saying that it is indeed self-defense. Now, there is, for those who aren't familiar with how court stuff rules, when Kyle went on the stand, he kind of opened himself up for the potential of smaller, lesser included crimes to be for the jury to consider those. So let's see what happens with that. Hopefully, it won't be a big thing. They did try to. If you've been watching, they've tried that whole to recreate a picture with AI and put pixels where the computer would guess they would be, to try to say that Kyle was raising it or pointing his gun before he shot Bicep Man. But that's not the case. We've seen the video. The video is there. I mean, multiple angles. But the defense's job, the prosecution's job, is to try to convince the jury of what they want. And for some reason, it appears as though I'm a little pixelated after this power surge. But we'll take care of that, hopefully. Let me check the courthouse feed, hit refresh here. Not yet. So, hopefully everybody had a good weekend, and I'm ready today for Kyle to be set free, and hopefully the cities don't burn. There have been, I'm sure you've been following, there's been many threats about rioting, and there've been threats related to Kyle, and I believe the judge as well. So I don't know how legit they were or how hard they were investigated, but hopefully it's cooler heads prevail, I would hope. But I don't have faith in the those of us who think they need to go out and freak out and pillage and burn when their feelings aren't validated on things that happen in society. I guess that was a good politically correct way to say something that needs to be said, right? What do we got? Look left, poop on your page. Hoping justice will be served. Kyle is being used to target gun rights more than facing murder charges. And this will set precedent for future cases. And that is 100% true. Kyle is not the only thing that is on trial today. It is your family, your daughter, your mom. It's their right to self-defense that is on trial here. Make no mistake about it. They want this case to go their way so that they can use this as precedent. And no. Terrence Bain, TDOA, Jared, have you lost weight? I've been trying. There's only a couple things. I can't load my spine anymore. And for those who aren't like everything you think of like gym related, I can't have impact. So running, I can't do squats anymore. Anything that loads my spine, I can't do because I'm at high risk of severe injury, and it's just going to be like that. So I've been trying a couple things with kettlebells, but yes, I have 15 to 20 pounds I've lost depending on what I eat. But thank you. I'm trying. I used to be a gym person, but I can't anymore. It's been 2 years since the injury. Have you all heard from GOA or FPC or other 2A groups on this? Because I haven't. Yes, I have. Without putting out information that was entrusted to be held, because of certain issues, I'll just say this. The current defense team was offered help by many people and groups and stuff like that. And the defense team is the way it is right now because of their choosing. So that's take that for what you will. We got about 3 more minutes, so I'm going to keep checking the feed. Erica, thank you. Just can't wait to get into this. I'm in Wisconsin all week this week. I expect I'll have to drive through interstate demonstrations. Probably that'll go around. It's sad that every time somebody has their feelings hurt, people need to come out in droves and demonstrate. Now, I will say that there are times where demonstrations and protests are 100% what should be done. I'm not somebody who's against protests and stuff, but if we're just going to protest everything now, we just look like a bunch of crying babies. And I don't have a filter, so that's just, I mean, there's a time and a place, I believe. But if I'm drinking from this plastic bottle and somebody doesn't like this plastic bottle, should they stop everything and doing and go protest about it? I don't believe so, but not everybody has to think the way I do, and I don't think the way everybody else does. David, any updates on the Supreme Court case? Nothing. We will not hear anything probably until June, end of June. That's when this current term for the Supreme Court ends. And when it's a landmark case like this or something major like this, that's when they typically do it right before they step out the door for their break. So I will we're all going to keep our ears open, but I wouldn't expect to hear anything for a while. This is the way it is. And Mel says, what irks me is the silence on the part of defense during the unreasonable line of questioning. Yeah, 100%, Mel. Thank you, by the way. The defense should have objected to a lot more than they did, and a lot of stuff got let in that probably wouldn't have if they made a solid objection. But we'll see. I've never seen like super chats and stuff admitted into a trial. I mean, I could be wrong, but I've never heard of that before. But we'll see. I guess it is a digital age now. Daniel, thank you. He says the mountains of East Tennessee are waiting for you. Yeah, I'm actually due for a trip again to go see my buddy Johnny. Go down and take another peek at Tennessee. Beautiful area. I love it. There's a good one. Oh, come on, come back. To the people that say it's murder, it's not murder, it's self-defense. 100% believe that as well. However, the jury will be the ones to decide. Oops, sorry, turn my ringer off. I've got cameras all around this place, so they pop off every now and then. Let me check the feed because it's just about time. All right, nothing yet. Let me check my second option here. The defense was garbage. I will say this could have been a lot better because the team that they had before they told people to bounce was amazing. Amazing. Seriously, it was a dream team, to use that type of term. But yeah, it is what it is. I guess it's not my decision. Ultimately, it's the family's decision. And we're going to try to get this feed here. I'm going to keep hitting refresh because it's going to start any minute. And then once it goes, I'll put it up. It'll be the bigger screen. I'll keep myself on as a smaller screen. If I do have to step away, you'll see an empty chair, but it won't be long. Gotta be that dad. All right, let's see if we can go back to the comments here in the chat. Hey, John. Cindy, thank you. Move to Ohio. No. I don't. I want to go warmer. There's another one. It's not murder. It's judicious use of lethal force. I have these Invisaligns in, and I'm lisping a little bit, so please excuse that. Boom, boom, boom. Almost. David says this trial is also a test for the media. If Kyle's convicted, this will empower mainstream media and social media platforms. I agree. Also, another like I hope the other side of that coin comes through and plays true. That if Kyle wins, he literally should do like the can't think of the kid's name. He was in D.C. and had the guy beating the drum in his face, and then he was slurred and slandered, and he ended up suing a lot of people and making a lot of money. Kyle can and should do the same here as well. That's we've come that far from center that people, news agencies think that they can have no evidence and just take off like they're judge and jury, like they're Judge Dredd, right? I don't know how they can stay doing what they're doing and not get well, I guess it's a statement of the times that we're in right now. Robert Stickney, the case will decide the future, the right to self-defense in our country for all of us. It will play a big part, that's for sure, a big part, because this is one of the first ones that is completely on video, one way or another, from him being approached and chased to where he defended himself, and that's a rarity. All right, let me get this ready here. Okay. All right. Sorry, guys. I just want to make sure I get this feed on. Mel, I fully expect malicious prosecution and defamation suits. Yeah, this is if he's acquitted by every member of the jury and it's unanimous, it's not able to be appealed. We still have the opportunity for directed verdict as well. So there's a lot of stuff out there. Mistrial with and without prejudice. I'm sure there'll be an argument for that today too. So those are things to keep your ears open for. Reese, before, could you go over what the court process is going forward? Last argument, and the jury decides in sentencing. Yeah. Today we're going to hear the closing arguments from each side. They each have up to 2 hours. Then they each have up to 30 minutes to rebut each one. And then it goes to the jury. And then the jury will deliberate as long as they think they need to come to a decision, hopefully, in Kyle's favor. And then they come back into the courtroom and decide it. It could be today. They could draw it out as long as they need to draw it out. There's no timetable once things go to the jury. So we'll have to play it by ear. I will put this whole transaction today will be here live on my channel. Again, this is going to be a long thing, and I can't do the whole day sitting here, so I might pop in and out. But today I will keep it on here. And so that way we can all stay in the know and see what happens. And I will say, guys and gals, like especially if you're in cities, like be prepared, prepare yourself, because my guess is if he gets acquitted like he should, then it's going to pop off again, because they didn't get their man, fact schmacks, evidence damned. That's just the way that portion operates now. Patriot 76, Rosenbaum lost his life doing what he loved, trying to touch a child. Yeah, I've seen that all over the place, man. And another question that I think should have been looked at more is, you got shot in the arm, but why you have a firearm when you're not supposed to? Not that I believe that his injury doesn't hurt him, but if you weren't doing what you were doing, then you wouldn't have. Put it this way. I like to say that his injuries are a direct result of his aggression towards Kyle Rittenhouse, especially holding a gun and pointing it at him. And my guess is any legal, lawful, anybody who owns a gun and carries a gun, whether they're doing it legally or not, you point a gun at somebody, like that's serious, and people will respond. Big boom boom mama poom flap. What's your opinion of poom flaps? Think you like them? Oh man. Robert says, glad I'm part of USCCA in case I ever have to go through this one day. Hopefully never, but rather than safe than sorry. 100%. That's the exact reason why I use USCCA for my family. And if you are thinking about it or just wanted more information, uscca.com/GNG. And again, they're another big supporter of this channel, and I use them for my family. I buy memberships. I don't get gifted one. I buy them for my family because I believe in what they do. There are other groups out there. Some may be better for you. Just choose the one that you think is best for you, because it comes in handy unless you have a couple million set aside for a rainy day fund in case you get sued. Chris Aiken, he left Gage Grosskreutz info and Messenger. Oh, left you. I'm sorry. Okay, I'll try to check that out. Hey, what's up, boys? Tennessee's where it's at. How you all doing? If you haven't checked out Black Diamond Guns and Gear, check them out. That's some solid dudes over there, and they live where Smith & Wesson is going. I believe it's the same town, right? Bruno, hopefully people will tune in. Looks like we have 2,500 plus people here now. Guys, before this kicks off, like it should be going, let me check these again. Hit the thumbs up and share it, please, because YouTube they just stomp on this. I mean, literally, when I put the post up last night that I was going to cover this live, I lost 150 subscribers in about 30 minutes. Maybe it's people actually leaving, but I have other thoughts. So please help get the word out. They don't like this. They don't like the truth getting out there. Nothing yet. The feed has not started. Just double checking and refreshing. Nope. Yeah. So we're just waiting for them to turn the cameras on. Yeah, it's hopefully people are watching because this is important. Boom, 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 boom. Fox comment. Everybody's watching this right now. Because regardless of what channel you watch, every channel has a skew, right? Every channel reports with a bias, whether they're most of them. I think it's really, really hard not to. So they're all watching this one way or another to say, yes, we were right, guns are bad, or see, the Second Amendment is a good thing. And you're going to see that on every news source out there. Second Lieutenant NC Cowboy, come to North Carolina, 2A organization here. We have a spot with your name on it. Thanks, man. Appreciate it. We'll see. It's getting closer and closer to me being free. Mod Mechanic, good morning and thank you. Mr. Imperfection Gaming Channel. I'm currently a felon. Will be getting my 2A rights back. Good. 5-year waiting period. I'm a big supporter of, if anybody's done, and I'll say this, that I have many members of my direct family who have done federal and state time. So I am not against felons getting their rights back. I am a big fan of, once you have given your debt to society is paid back, whatever it is, then your rights should be brought back, especially if they're going to expect taxes from your ass, right? If they want to take taxes, then you shouldn't be held away from any of your God-given rights. Now, that's not really a popular opinion, but that's the one I have. So good. I'm glad you're getting things settled back, man. I'm glad you are. Daniel Erickson, waiting on my November Blackout Coffee subscription shipment. Love the coffee. Thank you for your live streaming and closing arguments. Great commentary. Thanks, man. I appreciate it. Thank you for supporting the channel, and thank you for supporting Blackout Coffee. Really, really appreciate it. Thank you. What's this? Aaron, innocent of all charges, and we will deal with the consequences of doing the right thing. Should be innocent. Absolutely. Should be 100% acquitted. Mr. Big Kid, what's up, buddy? Arizona's where it's at. Too freaking hot. and too much brown. It's I don't know. It's I know it's nice out there, man, and I'm glad to have you as part of the team. Check him out too. Great great YouTube, great presence on Instagram. Really, he's doing big things. Keep it up, brother. Glad you're here. There we go. Sandman. I always forget his name. The kid in DC I was talking about earlier. Sandman was his name, his last name. What's this? David. USCCA is not available in New York State. Also, any chance, I can always say this kid's name, Gross Krauts will get that 10 million. Yeah, like I said earlier, USCCA is not allowed in every state. Some of the states have chased them out. So use the best. I believe there are other organizations that will probably serve New York. So choose what's best for you. And I don't think he's getting that 10 million. Little Eagle, yes. As we all know now, Corn Pop was a bad dude. A very bad dude. Come on, what's taking us so long? So usually for those who, oh, here we go, it's coming on. Give you 1 second to pop this over. And share. All right, here we go. Thank you, Mel.
All right. Has everybody received a copy of draft number 3 of the proposed instructions?
Yes. Yes, Your Honor.
And state objections? Requests?
We have no objection. I know the defense has asked that the self-defense instruction be read with every count which is applicable. If they're asking for that out of the abundance of caution, we would agree with that request.
All right, what about that?
Well, we had, we've all talked about things off the record in terms of our jury conference. I was under the impression that that was a requirement. I understand we're trying to streamline it. We're trying to not bore the jury with the instructions. I think that is, and if I'm wrong, I'm wrong, but I think that is what the law requires.
I inquired on the message last night. Is anybody familiar with authority on this subject that requires that? I guess I'll argue with you and then I'll hear the rest of what you have to say. You know, attention span, as you know, you speak to juries all the time. And when you start repeating yourself, you lose your audience mighty fast. They've got a lot to hear today from me and from you lawyers. And if I am reading the self-defense instructions 5 times, I would expect to lose the audience rather rapidly. And this is so typical of lawyers who are hidebound. We've always done it this way. And I will tell you that for years I have taken out common elements of things and put them in separate areas of the instructions. And once they learn what the term intent to kill means, I don't have to define it every single time it comes up. And I've never gotten, even to my knowledge, there hasn't even been an appeal on it. My job here is to communicate with the jury so that they understand what the law provides, and I think that can be done better, briefly and concisely, than by repeating the same old stuff over and over But given the position of the parties, if that's your position, we'll do it. But to me, it's a monumental waste of time, and it may end up having a negative effect. But I'm not going to mess around with a case of this magnitude over 2 days or 2 weeks to try. So if you think that risks everything to proceed as I've suggested, then we'll go with the long forms every time. I'm gonna have to count on you to make timely objection if you feel that I'm leaving something out on a particular count, because I've prepared it in the 36 pages of instructions. I've prepared them using a brief form without. There's already plenty of repeating going on. But if I have to do a longer, you're going to have to object if you think I'm missing something, or it's going to be a waiver. So you're forewarned. You have to make a contemporaneous objection. Is that clear?
It is, sir. And
All
the
right.
only one that you don't have it in that we had talked about a little bit was count 5. There's a lesser included offense of recklessly endangering safety.
Oh, yeah, I'm sorry. On that one, I do think that, no, I didn't put it in there, although it does in the final sentence. It says they have to be satisfied beyond a reasonable doubt that the defendant was not acting lawfully in self-defense. But I'll try to squeeze the content in there as well. And I guess I'm not sure that I agree with your statement that, well, let's take a look at it. And of course, the state wants me, if I read the self-defense portions in, then they want me to repeat every time retreat and provocation, which you have opposed.
They don't.
So they're going to hear that again. What?
They don't want that anymore.
They don't want it anymore?
I'm going to throw that request.
Let me know if it's still echoing. I'm
Because of
trying.
time.
Okay. I think I'll go back to bed. Okay. But in counts 2 and 3, I gave special instruction only with respect to Mr. McGinnis, because the law is different with respect to him. And we'll get to that. But I didn't reread it with respect to the account involving Mr. Jumpsuit Man.
One that I think is where, so you've done attempted first degree with self-defense, attempted second degree with self-defense. But the way that I read it, and if I'm reading it wrong, I know the court will correct me, on page 27 of the final instructions, it simply says, here are the elements. I didn't see self-defense mentioned
You're right.
in there.
You're right. Because as I did, now, let me see,
Thank you.
on counts, the attempt murder and the murder, on those, that's the pattern instruction. If I had my way, I think that's overly verbose. And,
All right, guys. I'm getting some people saying there's no echo, some saying there is. Let me know,
This, and I follow it,
and
I
I'll
follow
do
it,
everything
but-
I can to stop it on this
but,
end. There's a couple of settings I can
think it could
try.
be better stated, but I follow the guidance of the instruction committee because there's more of them than there is me, and they're very bright people. But and then on count 3, I gave a special instruction because of the situation with Mr. McGinnis, but I didn't on count 2 or count 5 because I relied upon the general principles of self-defense on which I instructed them. So if you want me to do it on 5, I need to do it on 2 too. And that's on 2 also. And that's right after they've just heard it.
Okay.
So, all right.
Thank you. I'm going to try to say as little as possible while he's talking.
The instruction makes it clear that self-defense is an issue for first degree attempt and second degree attempt. I don't know
I
if
understand.
right.
And
So
that's because that's from the pattern instruction. I understand you're thinking, well, because I didn't discuss it in the portion on reckless endangerment, that they're going to think it's not part of it. But the last sentence tells them, and if you are satisfied beyond a reasonable doubt that the defendant's conduct was not privileged under the law of self-defense, you should find the defendant guilty.
Can you see that under the recklessly endangering safety one, Your Honor? Is that what I'm just making? Is that what you're? Is that what you're telling me?
That's on the, yeah, that's on,
Actually, long gun is legal for him.
let's see, let's have a look at what I said on 5. See, if I had set this up, I would have put a, well, I'm not going to say what I would have done. You know, you're right. Well, maybe I misunderstood what you wanted. Did you want the whole self-defense instruction discussed again, or just the clause? And if you are not satisfied beyond a reasonable doubt that the defendant, or that I should say it, is all 3 elements of the crime of endangering safety of the first degree have been proved, and that the defendant is not privileged under the law of self-defense, you must find the defendant not guilty.
I think that's fine as long as the self.
You don't need
as,
the whole-
as long as they're aware that
the whole
self-defense
instruction.
is an option.
Yeah, well, you're right. All right, I'm misunderstanding what your email said. So, if you are not satisfied beyond a reasonable doubt well, there's more missing there than that. You know that? There's not the clause about if you are satisfied. All right, so it'll read at page 27, the fourth line will be, if you are satisfied that all 3 elements of the crime of reckless endangerment have been proved, and that the conduct of the defendant was not privileged under the law of self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as charged as submitted. If you are not so satisfied, then you must find the defendant not guilty.
Okay.
Is that satisfactory? Okay. What's next?
I have nothing else on the instructions.
Defense?
So, Judge, and this is more for the record, you've already made, I think, preliminarily, you had talked a little bit about the Ritchie McGinnis instruction,
Right.
which is on page 8 and 9.
Right.
And the position that I had taken was one of the lines says, but the defendant does not have a privilege of self-defense as to Richard McGinnis. After that, there's discussion about self-defense and what that means. On page 9, there's a sentence that says, if the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. I had told you in an email that all the parties were involved in that. I thought that there was some incongruence in that in terms of how that reads. I know the court disagrees, but just for the record, I wanted to make sure that that was on there. Because I do think it's confusing. However, I know it's the pattern instruction. I know you took it from the pattern.
Yeah, I'm not even going to argue with you. It is the pattern, and I'm not going to argue with you that it is confusing. But It's an accurate statement of the law. Mr. McGinnis does not have a self-defense status because the defendant has no right of self-defense as to any harm he would cause to Mr. McGinnis. And that's what the instruction is telling the jury. But if he was acting lawfully in self-defense with respect to Mr. Rosenbaum, then it kills one of the elements. I think I'm reading that right. It gives him the absolution with respect to the element of what is the precise element? It's
Number 2.
part of element, yeah. Unreasonable and substantial risk of death. It says then that the jury can't find that. Well, if they can't find that, they can't find one of the elements, so they have to find the defendant not guilty.
Judge, do you think it's appropriate then on page 9 to say if the defendant was acting lawfully in self-defense as it relates to Joseph Rosenbaum?
At
His
what
conduct
point
in
do you
this-
want that put in?
I just think that makes it clearer. I mean,
Where do you want to put in?
Where did you say?
Yeah.
On page 9, it would be right. So there's a subheading determining whether the beliefs were reasonable. I think it's the third or fourth to last sentence says if the defendant was acting lawfully in self-defense, comma,
Okay, with respect to
Joseph Rosenbaum.
Joseph Rosenbaum.
His conduct did not create an unreasonable risk to Richard McGinnis.
Yeah, I'll do that. Any objection?
No.
Okay. Okay, what's next?
Just, Your Honor, that on page, these are small, but on page 34, 2 of the witnesses, you said one of the witnesses had been convicted of a crime. Mr. Grosskreutz had been convicted of a crime, and Mr. Smith had been convicted of a crime as for a juvenile adjudication. So I think if you just say multiple witnesses had been, something like that.
Okay. What page is that on?
I'm sorry, 34. And we are asking for the
Do
caution.
you want the word some instead of one?
Or multiple? Yeah, some is
Several?
fine,
How many was it? 2.
that I recall.
Well, I don't think you asked this sort about hers. There was another witness with convictions, but I don't believe the question was asked. So 2.
What was the answer? All right, I'll put down 2 then.
And then there was some conversations regarding a cautionary instruction regarding Mr. Armstrong.
Yeah, I really struggled with it.
And we had proposed the instruction to the court, which I think we took off of 245 or something like that.
Yeah.
So we are asking, based on his testimony, that the court instruct with that modified 245 instruction as related.
Let me know if the echo has stopped. I'm going to try to keep my mic off during all this. For some reason, there's some feedback.
Did you want to be heard?
Well, I would stand by what I indicated over the weekend in my email, but I believe that I'm looking up the specific instruction. Say 245?
I think it's
No, it's testimony of accomplices.
Yeah, and that's a good model for it. That was what I had planned on using if I had drafted it myself.
Judge, I just don't think it's necessary. The evidence was received. The points that the defense wanted to get into were made on cross-examination. Giving any kind of instruction on this would essentially be telling the fact finders how to weigh the evidence. I proposed some different wording. You should not base a verdict of guilty upon it alone unless after consideration of all the evidence you are satisfied beyond a reasonable doubt that the defendant is guilty is completely inappropriate. I can understand where it's appropriate if you're talking about accomplices, but certainly not when we're talking about a one picture out of 100 and some odd exhibits. So I don't believe it's appropriate. I don't believe it's necessary. I believe that these arguments about pixels and zooming are specious, that their expert used a very similar software program with zooming, was cropping.
There was no objection then, you see, that's,
I understand.
My-
There's no basis for an objection, and they know that.
I don't know. I don't know that. Maybe they do. I don't know. I can't read their minds.
This is a forensically sound program used by a forensic analyst who's trained. This image was peer reviewed. If they want to discuss the proprietary algorithms and how a analyst would not know a proprietary algorithm contained in the software that they are using, that is an industry standard, they can go ahead and argue that. But to give an instruction that tells the jury essentially to ignore this evidence unless everything else proves it is way too far.
Well, this whole business about, well, I don't want to say the whole business, but the Daubert rule is the product of the abuse of so-called scientific evidence by attorneys. There were companies, pension funds, individuals were bankrupted because of legal decisions that were made on the basis of so-called science, which was later shown to be garbage. So when you come in here and you tell me, well, this is what they rely on, I think that's fine, except when my common sense tells me, well, wait a minute, what's happening here when you get an image that is consistent of I'll say it again, let's say 2,500 pixels, and you blow it up to 25,000 or 250,000, and you don't really know what fills the vacant space, that's a little struggle for me. And this is not being used to decide which camera I'm going to buy or which phone I'm going to buy when I'm at the store. This is being used to decide about whether someone's innocent or guilty of a crime. So that's why I was when the witness answered, he didn't know. And the only reason I left here and I troubled about it. And in the end, I decided, well, wait a minute, we allow this kind of thing to happen in DWI cases where the officer is asked, well, how does the machine work? I don't know. I just am trained how to operate it. But there is a difference there. That has already passed judicial scrutiny, and this method has been judicially determined to be accurate. Has that been done in this? I don't know. So that was when I was thinking, well, maybe I should give a cautionary instruction. I ultimately, you convinced me in our exchanges that I don't want to be meddling and commenting on the evidence. I will tell you this, assuming that there's conviction, one or more, assuming that other motions don't contaminate the whatever outcome there is. If it comes out at some time that the method used produces unreliable results, this is going to fall like a house of cards. Because you're basing this extremely important segment of the evidence on something that I'm really queasy about. But as I said when I left here Friday, this is the jury's case. It's not mine. And I'm going to let them decide. They have your photographs and your video, and they've got the testimony of the person who's worked with it, who knows a lot more about this stuff than I do. So I've decided to leave it alone. So I'm not going to give an instruction on it, but I've made my record on the high risk that I think it presents for the case. Okay, what's next?
The two last things, Judge. The court had modified a little bit count 6, which was the
I did.
date. Okay, so The third element that you have listed there is the dangerous weapon was a rifle that had a barrel length of less than 16 inches or an overall length of less than 26 inches. We have pulled the transcript, talked, and looked at it. Detective Antaramian was asked if this was a short-barreled rifle. He had answered no, he did not believe that it was. That's the only information regarding that.
Was the gun offered as an exhibit?
Yes,
That is evidence
correct.
enough in itself. The jury can measure it.
Okay. Fair enough. I just didn't, the way
Yeah.
that I looked at it, there was no other information that a reasonable juror could believe that count 3's been met. So
What are you telling me?
that I'm asking that you take it from them.
They're asking me to dismiss the case for failure to prove.
This counts 6. Judge,
Count 6.
there have been many discussions about this count. I'm not going to rehash everything. The state disagrees with the interpretation the court has established. We do not believe this jury instruction is appropriate. We do not believe that the exception or affirmative defense, or whatever you want to call it, was properly raised. We argued about all that on Friday. I'm not going to rehash it. I believe it should go to the jury, and if the jury believes that it was not proven beyond a reasonable doubt, they can return a verdict on that. But the state has objected all along, or has given its version all along. We stand by that version. I believe that this jury instruction essentially swallows the entire statute. We've gone over that before. So I believe that if they raise an exception, then it should go to the jury. We would like the standard instruction. Clearly, the court's not going to do that.
Well, up to now, the motions were motions to dismiss the complaint. And you filed a very nice brief, which well explained what the law is. And of course, we were dealing with what the complaint stated and whether the complaint stated sufficient facts to bring the case to court. And the court is confined on that kind of a motion to what's in the complaint and whether it meets the law. And as you pointed out, these defensive matters are affirmative defenses, and the DA doesn't have to plead them. So that's why I ultimately deny.
So real quick, if an echo comes in, it's going to be on their end. I have shut off my audio when I am not talking, so I can't even pick up an echo. So I guess we'll have to deal with that. But thank you all for being here. Hit that thumbs up.
There's access to the Court of Appeals all along here. Well, I guess that's not fair for me to say because I was sitting on it. But so shame on me. But I ultimately read the statute and have, even when I ruled on the motion to dismiss, I was of the opinion that the statute was as interpreted by the defense. But there was not sufficient grounds to grant the motion to dismiss. Is the firearm here now?
Yes.
We can either measure it or you can stipulate that it does not meet what I've stated are the requirements. And if it is out of compliance, if the barrel length is less than 16 inches or an overall length less than 26 inches, then I'll deny the motion. If it does not meet those specifications, then this defense motion will be granted.
We are not disputing that the barrel is appropriate.
Isn't legal?
It is not a short-barreled shotgun or a short-barreled rifle. Yes,
Either by.
correct.
All right, and then count 6 is dismissed. What's next?
One other thing, I had filed on November 8th, we had addressed a motion for mistrial with prejudice. The court had taken that under advisement. what I had informed the court was, so I have filed something in writing on that. I know the court likely hasn't had an opportunity to review it. I don't know. I'm
I haven't
assuming,
even seen it.
okay. I'm assuming that we're going to go obviously through closing arguments today, but I did want to make sure the court was aware that it had been filed, and at some point have the court make a final ruling on it, just for the record.
I will.
Okay.
If it's necessary. Okay. Came in this morning? Okay. Okay, anything else?
Were you ever able to get the defendant's interview link that we sent to play? The Washington Post story?
I did receive that. I did receive that.
It relates to the motion. That's the only reason I asked. The defense motion, it relates to that.
Well, I'm not going to take up the motion now.
I understand now. I just knew there were technical problems. I just wanted to make sure they were ironed out.
I did receive it.
Okay.
Okay. Anything else right now?
Judge, are you done? Attorney Charles? Yeah. The only thing, Judge, in our arguments, we would like to indicate that pointing a loaded AR-15 at someone without reasonable justification would be a criminal act without citing, the specific statute, but that pointing under 941.20 is a crime. We would like to point that out, and we just wanted to preview that. So if there's objection, we can handle it now.
Okay. Do you want to respond?
We would object. This is once again relying on the exhibit that is so far out of focus, and there's been nothing in the record. When I specifically asked the Detective Howard regarding the strong arm robbery, I asked about it. Strong arm robbery while masked. I asked about it. It's in the record.
The struggle I'm having with that is, and I will, well, I'll leave that. How do we know it was pointed at or toward Mr. Zeminski or Mrs. Zeminski or whomever? You have a theory that it was pointed in that direction. I agree with that, but the statute's prohibition is pretty explicit, and I'm not sure that the evidence that you have, especially because it's just not just especially, but in part because it's just a regular photograph. It's not multidimensional. It doesn't show the exact area at which the firearm was aimed.
Judge,
Even if you see the firearm.
again, the photograph is perhaps the fifth or sixth most relevant piece of evidence on this topic.
Most what?
Fifth or sixth most relevant piece of evidence on this topic. We have testimony, we have videos. I'm not going all over that again. The defense submitted their own exhibit of the FBI video with the Zeminskis denoted as being the only two that were on that side of the Duramax. Mr. Zeminski starts out by one of the windows of the Duramax. I guess it would be the rear passenger side window. And so there's no real dispute that they are in that area, and that is where that he is pointing the weapon. It's for the jury to decide if he's pointing at Zeminski's or not.
So it's for the jury to decide. It is not for the jury to speculate. I mean, let's look at the statute. That's a good place to start. Was it 941.20? Yeah. And that brings up, a separate issue, I suppose, that what is the role of Mr. Rosenbaum, assuming the defendant violated that statute? That's the very theory that the state has proceeded on in the first place, is that the defendant was a vigilante who was getting himself involved in something that was not his concern. And now you're telling me that would justify Mr. Rosenbaum's actions?
Boom.
I'm kind of struggling with that.
That's big.
How would that justify? I mean, what does the jury do with that?
I don't fully understand the court's question. I would also note
What
that he
is
did
the,
point
you,
the weapon
the,
at Mr. Rosenbaum.
pardon me?
He also pointed the weapon at Mr. Rosenbaum before the shooting. While he's being pursued, he turns and points it at Mr. Rosenbaum.
Well, there's no question about that.
Correct.
He's being chased by him.
Pardon me?
I said he's being chased by him.
Well, they've made it much more complicated. It used to be points or aims of firearm at another. I'm not seeing that exact language anymore, but I'm not seeing it here in the statute that there'd be a broad enough sweep to capture some wrongfulness in just pointing the firearm towards the west without evidence that it was pointed specifically at or toward another. What am I missing?
1A is endangers another safety by the negligent operation or handling of a dangerous weapon.
Could you start that over?
Sure. 1A is endangers another safety by the negligent operation or handling of a dangerous weapon. We would argue that it is. If the court feels otherwise, we just simply will talk about it and not call it a
Well,
crime.
where was the firearm aimed? You say at the Zabinskis. I didn't hear the Zabinskis come in here and say that. Who said it?
Except for looking at the video, and that's who's over there. That would be the only
I
other.
mean, pardon?
Looking at videos and indicating that those are the ones who are over there, that would be the only evidence.
I can't say it. I'm not saying it didn't happen. I'm saying I don't think I can give an instruction to the jury telling them, something when I don't see the statutory.
We're asking for instruction. In our closing, in our arguments, we just wanted to say that it's.
I think it would be okay for you to state what the law says, but you have to be careful because the jury cannot be invited to speculate. So I don't want to, there's such a universe of possible statements that could be made that I don't want to try to, rule in advance. I've refrained from doing that. I always try to, because I can't read your mind, but, so I'm not going to say they can't mention that at all, that it's unlawful to point a gun at somebody. The jurors probably have a sense of that anyway. But as to what might be said, I can't tell you what's in and out of bounds. Okay, what's next?
All we got.
Okay, ready for the jury? I'll probably take a break after the lengthy instructions. And call from the outside. Let's see.
All right, guys. So while we have a break here, a quick break in the action, count 6 was thrown out. So for those who aren't aren't aware of what the counts are, I'm going to read them real quick. Hopefully I can get it in before the judge continues here in Kenosha. So count 1 is first-degree reckless homicide, and that was for the Rittenhouse is accused of this crime in connection with the fatal shooting of Joseph Rosenbaum, Class B felony, carrying a basic sentence of up to 60 years in prison. Counts 2 and 5 is first-degree reckless endangering safety. This law defines this crime as recklessly endangering another person's safety under circumstances that show utter disregard for human life. And Rittenhouse is charged with reckless endangering 2 people who, according to the criminal complaint, had shots fired towards them. Okay, still on the phone, but were not hit. That's McGinnis and an unknown male in the video. It's Class F felony, carries a basic sentence of up to 12 and a half years in prison and a fine of $25,000 or both for each of those 2 counts. And we still have audio off in the court. Count 3, first-degree intentional homicide, and that is for the alleged shooting of Anthony Huber. Count 4 is attempted first-degree intentional homicide, and that is the Class B felony. He's charged in connection with the shooting of Gage Grosskreutz. It carries a basic sentence of up to 60 years in prison. And count 6, which was just dismissed, is the possession of a dangerous weapon by a person under 18. Though Wisconsin is an open carry state where it is legal for adults to carry firearms openly, state law prohibits minors from doing so. So Mr. Rittenhouse was 17 at the time of the shooting. This crime is a Class A misdemeanor that carried, because it's gone now, a basic sentence of up to 9 months in prison, a fine of up to $10,000 or both. And the aggravating factor for that charge was the use of the dangerous weapon. Provision of Wisconsin law extends the maximum sentence for crimes committed while possessing, using, or threatening to use a dangerous weapon. The criminal complaint invokes this provision for all 5 felony counts. In each case, it would add up to 5 years to the prison sentence for that individual count if he is convicted. So the use of the dangerous weapon is going to be a big one for the defense. So we will see. Hopefully the judge will be... I've never seen a judge take a phone call on the bench. That's interesting. At least not on his cell phone. But I'm glad that 6 is gone, is dismissed. And for those who are... Everybody like myself is like, let's just get into this. Instructions for the jury. Now, the jury's not in listening to this, obviously, if you didn't know. This is big. The instructions to the jury is huge, because when the jury does come in, the judge says something incorrectly, it can be tossed right there. So judges have to get this stuff right. And it looks like we'll be coming back here shortly. But thank you for everybody for joining. Please hit the thumbs up so that more people see it and share it, because YouTube is stomping on it. We're currently over 3,600 people. Thank you. It means so much to me. And
Nice weekend,
there
and
you go.
We'll begin our final phase of our case, which is my instructions, and I'm going to instruct you on the principles of law, which
Talking
you are
to the jury.
follow in considering the evidence and in reaching your verdicts. It is your duty to follow all of these instructions, regardless of any opinion that you may have about what the law is or what the law ought to be. You must base your verdict on the law as I give it to you in these instructions. Apply that law to the facts in the case which have been properly proved by the evidence. Consider only the evidence received during the trial, and the law is given to you in these instructions. And from these things alone, guided by your soundest reason and best judgment, reach your verdict. If any of you has any impression of my opinion as to the innocence or guilt of the defendant, you must disregard that impression entirely and decide this case solely as you view the evidence. You are the sole judges of the facts, and I am the judge of the law only. Keep in mind that the information is nothing more than a written formal accusation against the defendant, accusing him of the commission of crimes. You are not to consider it as evidence against the defendant in any way, and it does not raise any inference of guilt. The information contains 6 counts of charged unlawful behavior against the defendant, and to each of these he has entered a plea of not guilty, which is a demand that the state prove every element of each crime beyond a reasonable doubt. Self-defense is an issue in this case, as and I might interject here. Count 6 is no longer part of your consideration. That was the firearm charge. So that will not be something that you will need to address. You'll need to address only the first 5 counts. Self-defense is an issue in this case as to each of counts 1 through 5. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. The law of self-defense allows the defendant to threaten or intentionally use force against another only if he believed that there was an actual or imminent unlawful interference with his own person, and he believed that the amount of force which he used or threatened to use was necessary to prevent or terminate the interference, and his beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if he reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to his own person. A belief may be reasonable, even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offenses. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the standpoint of the jury now. There is no duty to retreat. However, in determining whether the defendant reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether the defendant had the opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. You should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack, and who does provoke an attack, is not allowed to use or threaten force in self-defense against that attack. However, if the attack which follows causes the person reasonably to believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense, but the person may not use or threaten force intended or likely to cause death unless he reasonably believes that he has exhausted every other reasonable means to escape from or otherwise avoid great bodily harm. Counts 4 and 5 require intent to kill as part of the elements. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent to kill have existed for any particular length of time before the act was committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to have existed at the time of the act. You cannot look into a person's mind to determine intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be confused with motive. Proof of motive is necessary. While proof of motive is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of the defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. The first count of the information charges that on or about Tuesday, the 25th of August of last year at the city of Kenosha in this county, the defendant recklessly caused the death of another human being, Joseph D. Rosenbaum, under circumstances which show utter disregard for human life. First-degree reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The circumstances and the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances relating to the conduct. If, as to the first count, you are satisfied beyond a reasonable doubt that both elements of this crime have been proved, and that the defendant was not acting lawfully in self-defense, as I have instructed you on the law of self-defense, then you should find the defendant guilty of reckless homicide of the first degree as charged in the information. If you are not so satisfied, then you must find the defendant not guilty on this count. Counts 2 and 3 of the information accuse the defendant of the crimes of recklessly endangering safety. Although the elements of each of these charges are identical, the rules of self-defense which apply to them are not. The second count of the information charges that at the same time and place, the defendant recklessly endangered the safety of Richard McGinnis under circumstances which show utter disregard for human life. The third count of the information charges that at the same time and place, the defendant recklessly endangered the safety of an unknown male under circumstances which show utter disregard for life. First-degree reckless endangerment, as defined in the criminal code, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless endangerment of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances related to the conduct.
It's one of the best text tones. I don't know who's doing it in the courthouse and why they haven't said stop, but I got to get it now.
When I was instructing you a moment ago on reckless homicide, I indicated there were 2 elements. There are actually 3. I did read all of the ingredients, but I'm just going to reread a portion of that instruction so it's clear that there are 3 elements to that crime. And I also used the word both of the elements, and it's actually 3. So I apologize for that mistake. And we'll stop with the reckless endangerment for a moment and return to the reckless homicide. And the elements of reckless homicide are
Good fix by the judge,
the defendant
guys.
caused the death of another, that he did so by criminally reckless conduct. And the third element, which I read as part of the second, is that the circumstances of the defendant's conduct showed utter disregard for human life. And what tipped me off is, other than causing death, the reckless endangerment, which I've been reading now, has those same 3 elements. So utter disregard for human life is one of the elements of both crimes. And in order to convict on the first count, you must find the presence of all 3 of the elements of first-degree reckless homicide, and also find beyond a reasonable doubt that the defendant was not privileged under the law of self-defense. Is that clear? Thanks. Thank you very much. Getting back to the reckless endangerment charge with respect to Mr. McGinnis, there is evidence in this case that the defendant was acting in self-defense as to Joseph Rosenbaum. The fact that the law may have allowed the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct, which showed utter disregard for human life. But the defendant does not have a privilege of self-defense with respect to Mr. McGinnis. So the defendant would enjoy a privilege of self-defense with respect to Mr. Rosenbaum if you find the factual ingredients of that. But that doesn't mean that the fact that if he endangered the safety of Mr. McGinnis was privileged under the law of self-defense, because Mr. McGinnis was not attacking him. However, you must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct, which showed utter disregard for human life. but he does not have a privilege of self-defense as to Richard McGinnis. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed that there was an actual or imminent interference with the defendant's person, that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. The defendant may intentionally use force which is intended to or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily injury to himself. A belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now.
So y'all know, if you have your cell phone on during court while it's in session and it goes off like that, you could be
You
placed in
should
contempt.
consider the evidence relating to self-defense along with all the other evidence in the case in deciding whether the defendant's conduct created an unreasonable risk of death or great bodily harm to Richard McGinnis. If the defendant was acting lawfully in self-defense with respect to Joseph Rosenbaum, his conduct did not create an unreasonable risk to another. The burden is on the state to prove the burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of the defendant's conduct showed utter disregard for human life. If, as to each of these counts, you are satisfied beyond a reasonable doubt that the elements have been proved and that the defendant was not acting lawfully in self-defense, you should find the defendant guilty of reckless homicide of the first degree. If so satisfied, then you must find the defendant not guilty. The fourth count of the information charges that at the same time and place, the defendant caused the death of another human being, Anthony M. Huber, with intent to kill that person. This is a charge of intentional homicide of the first degree, and you must consider first whether the defendant is guilty of that offense. If you are not satisfied the defendant is guilty of first degree intentional homicide, you may consider whether or not the defendant is guilty of second degree intentional homicide or first degree reckless homicide, which are less serious degrees of criminal homicide. The crimes referred to as first and second degree intentional homicide and first degree reckless homicide are different degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide defined by law depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that the defendant have caused the death of another. First and second degree intentional homicide require the state to prove the additional fact that the defendant have acted with the intent to kill. First degree reckless homicide requires that the defendant acted recklessly and that the circumstances of his conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his own person by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. As applied to this case, the effect of the law of self-defense is the defendant is not guilty of any homicide offense if the defendant reasonably believed that he was preventing or terminating an unlawful interference with his own person, or reasonably believed the force used by him, and reasonably believed that the force used by him was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of second-degree intentional homicide if he caused the death of another human being with intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. The defendant is guilty of first-degree intentional homicide if he intended to cause the death of another with the intent to kill and did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of first-degree reckless homicide if the defendant caused the death of another by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life. You will be asked to consider the privilege of self-defense in deciding whether the elements of first-degree reckless homicide are present. Because the law provides that it is the state's burden to prove all facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second degree intentional homicide or for first degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find the defendant not guilty. The facts necessary to constitute each crime will now be defined for you in greater detail. First degree intentional homicide is defined in the criminal code as committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first degree intentional homicide also requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Before you may find the defendant guilty of first degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another. Cause means that his act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill the other. Third, that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The third element of the first degree intentional homicide requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe that the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first degree intentional homicide is considered, the reasonableness of the defendant's conduct, when first degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether those beliefs are reasonable is important only if you later consider whether the defendant is guilty of second degree intentional homicide. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another with the intent to kill this is Mr. Huber, with the intent to kill, and that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, intentional homicide. If you are not so satisfied, then you must not find the defendant guilty of first degree intentional homicide and must consider whether the defendant is guilty of second degree intentional homicide as defined in the criminal code, which is a lesser included offense of the first degree intentional homicide. there are hierarchies of cases in the law. Typically, first degree is the highest offense. Then lesser included are crimes that are of the same nature with many common elements, but some differences. So there's a sequence of verdicts that are going to be submitted to you with respect to this count. And that's what we're going through at this time. So we'll take on now the, but let me advise you, you should make every reasonable effort to agree unanimously on the charge of intentional homicide of the first degree before considering the offense of second degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first degree intentional homicide, you should consider whether the defendant is guilty of second degree intentional homicide. Before you may find the defendant guilty of intentional homicide of the second degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements of this crime were present. First, that the defendant caused the death of another. Second, that he acted with intent to kill another human being. And third, that he did not reasonably believe that he was terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. These same definitions apply to your consideration of second degree intentional homicide. The third element of second degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force which was used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state have proved one of the following. First, that a reasonable person in the circumstances of the defendant would not have believed that he was preventing or terminating an unlawful interference with his own person, or that a reasonable person in the circumstances of the defendant would not have believed he was in danger of imminent death or great bodily harm, or that the reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the standpoint of the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged offense. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being with intent to kill, and did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of second-degree intentional homicide. If you are not so satisfied, then you must not find the defendant guilty of second-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide as defined in the criminal code, which is also a lesser included offense of first-degree intentional homicide. Again, you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide, which is a crime committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before the defendant may be found guilty of reckless homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another human being. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct, which means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created the unreasonable risk to another. If the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to establish beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous the conduct was, the obviousness of the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in the case that the circumstances of the defendant's conduct showed utter disregard for human life. Consider also the defendant's conduct after the death Consider also the defendant's conduct after the death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time that the death occurred. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, and that the defendant's conduct was not privileged under the law of self-defense, then you should find the defendant guilty of reckless homicide of the first degree, as submitted. If you are not so satisfied, then you must find the defendant not guilty on the fourth count. The fifth count of the information charges that at the same time and place, the defendant attempted to cause the death of Gage Grosskreutz with intent to kill that person, a crime of attempted first-degree intentional homicide. With respect to this charge, you must first consider whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty of attempted first-degree intentional homicide, you must consider whether or not he is guilty of attempted second-degree intentional homicide or first-degree reckless endangerment, which are less serious degrees of criminal homicide. The crimes referred to as attempted first and second-degree intentional homicide are different degrees of homicide. Again, that is the taking of the life of a human being. The degree of attempted homicide is defined by law depending on the facts and circumstances of each particular case. While the law separates intentional homicides into two degrees, there are certain elements that are common to each. Both attempted first and second-degree intentional homicide require that the defendant have intended to kill another, that he did acts towards the commission of that crime which indicate unequivocally, under all the circumstances, that he had formed that intent and would have caused the death of the other, except for the intervention of another person or some extraneous factor. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another under the following circumstances. Force is used for the purpose of preventing or terminating what the person reasonably believes to be an unlawful interference with his own person or by the other, and he uses only that amount of force which he reasonably believes is necessary to prevent or terminate the interference, and the person may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. If you find that the elements of attempted first or second degree intentional homicide have been proved in this case, the effect of the law of self-defense is as follows. The defendant is not guilty of either attempted first or second degree intentional homicide if he reasonably believed that he was preventing or terminating an unlawful interference with his own person, and he reasonably believed the force used was necessary to prevent death or great bodily harm to himself. He is guilty of attempted second degree intentional homicide if he actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. The defendant is guilty of attempted first degree intentional homicide if the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to him. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a guilt beyond a reasonable doubt, you will not be asked to make a separate finding as to whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has proved the necessary facts to justify a finding of guilty for attempted first or second degree intentional homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find the defendant not guilty. The elements of each crime will now be defined for you in greater detail. Before you may find the defendant guilty of attempted first degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant intended to kill another. Second, that he did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of another, except for the intervention of another person or some other extraneous factor. Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone other than the defendant, include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside of his control. The third element is that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The third element of attempted first degree intentional homicide requires that the defendant did not actually believe the amount of force was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe that he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe that the amount of force used was necessary to prevent imminent danger of death or great bodily harm to himself. When attempted first degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of attempted second degree intentional homicide. If, as to the fifth count, you are satisfied beyond a reasonable doubt that the defendant intended to kill another human being, and that his acts demonstrate unequivocally that the defendant intended to kill and would have killed the other except for the intervention of another person or some other extraneous factor, and that he did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of attempted first degree intentional homicide. If you are not so satisfied, then you must find the defendant not guilty of attempted first degree intentional homicide and must consider whether the defendant is guilty of attempted second degree homicide intentional, which is a lesser included offense of intentional homicide of the first degree. Again, you should make every reasonable effort to agree unanimously on the charge of attempted first degree intentional homicide before considering the offense of attempted second degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in a unanimous agreement on the charge of attempted first degree intentional homicide, you should consider whether the defendant is guilty of attempted second degree intentional homicide. Before you may find the defendant guilty of second degree intentional homicide, the The state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant intended to kill another. Second, that he did acts which demonstrate unequivocally under all of the circumstances that he had formed that intent and would have caused the death of another human being, except for the intervention of another person or some other extraneous factor. The third element is that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of intent to kill, unequivocally, another person, and extraneous factor. The same definitions apply to your consideration of attempted second-degree intentional homicide. The third element of attempted second-degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state have proved any one of the following. First, that the reasonable person in the circumstances of the defendant would not have believed that he was preventing or terminating an unlawful interference with his own person, or that a reasonable person in the circumstances of the defendant would not have believed that he was in danger of imminent death or great bodily harm, or that a reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's belief must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged conduct. If as to the fifth count you are satisfied beyond a reasonable doubt that the defendant intended to kill, and that the defendant's acts demonstrated unequivocally that the defendant intended to kill and would have killed another, except for the intervention of another person or some other extraneous factor, and that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of attempted second-degree intentional homicide. If you are not so satisfied beyond a reasonable doubt that the defendant is guilty of attempted first or second-degree intentional homicide, you must determine whether the defendant is guilty of the lesser included offense of first-degree recklessly endangering safety, as defined in the criminal code, which is a lesser included offense of attempted first and second-degree intentional homicide. First-degree recklessly endangering safety, as defined in the criminal code, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of first-degree reckless endangerment, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being. Second, that he did so by criminally reckless conduct, which means that his conduct created a risk of death or great bodily harm to another, and that the risk of death or great bodily harm was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. Third, that the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. If you are satisfied that all three elements of this offense have been proved beyond a reasonable doubt, and that the state has proved beyond a reasonable doubt that the defendant was not acting lawfully in self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as submitted. If you are not so satisfied, then you must find the defendant not guilty. You are not in any event to find the defendant guilty of more than one of any sequence of offenses. So you can return only one verdict per count. You should consider the charged offense first. If you find unanimously that the defendant is guilty of the highest degree of crime, you need not consider lesser included offenses. If you decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense, I've got myself into a mid-sentence and I don't like it.
So, quick sidebar. Judge is trying to figure out what he wants to say the right way, I guess. I know this has been very long and daunting. The instructions to the jury is extremely important because if done wrong, case gets thrown out, and then they'd have to do this all over again. So the judge is being careful in what he's saying. He has to say it in particular ways. So I guess good on him for not pushing through and making a boo-boo that could cause us to start all over again. So we shall see. And then after this, it will be time for the closing arguments. This is the longest part of these types of days. Thank you, Lynn. It's a long day for sure. But if you're Kyle, you're facing the rest of your life in prison for defending yourself. And, there, as you've seen, there are people who have different points of view. And it just goes to show how America is looking at this case. There are people who say this is a slam dunk case of self-defense. And there are others that say, well, because he shouldn't have been there, they can't get past that point. And others who don't believe in the right to self-defense. So to each their own. But the law says you are allowed, you can defend yourself if you are facing death or imminent serious bodily harm. So that is what it is. Don't really know how to say that. If people don't like that, it doesn't really matter. That's just the way it is. And you don't have to lay down and be murdered. You don't have to lay down and get hurt. And you don't have to wait to be punched before you fight back either. So we'll see what the jury comes up with here. It sounds like the judge is about to wrap up the instructions to the jury. And then, like I said, it'll be time for closing arguments. And it looks like they're going back. But I do want to say thank you to Daniel and let us go back to the judge.
The concern that I have, and I worked with the instructions all weekend, and we discussed them by email. And then I'm reading them, and little things are striking me as I read them. But the jurors are never told to actually discuss self-defense except in the context of charged offenses. And what I was about to say to the jury and decided I better talk to you people beforehand is if the jury gets into a discussion of a charged offense, any charged offense, but let's use this one as an example. And they decide that the elements are there and he wasn't acting lawfully in self-defense, they're done. They never discuss the lessers. What?
Was or was not acting lawfully in self-defense?
Well, let's say if they decide the elements are there, but he was not acting lawfully in self-defense, they're done. Then they find him guilty of the charged crime. What if they discuss count 1 or count 5, I should say, and decide that the elements are there, but they all decide it was privileged under the law of self-defense? They're not. Is there anywhere that they're being told? Are they being told you're done? See, under the old law, we did do that. Is that in here? Where is it saying that? Yeah, that's when I used to construct these from scratch. And I would tell the jury which I was just doing now, that, once you have exhausted this, you're done. As opposed to having them needlessly go through these lessers if they've already concluded and this is a case where this could happen. I'm not saying it should or would. I'm saying it could, that they would decide, well, yeah, the elements are there, and then they make a decision. And if all of them say, well, they all vote not guilty on the basis of valid self-defense, then they really should not be considering lesser included. Am I wrong about that?
So if they find perfect self-defense on the charged count,
Yeah.
they should be told.
You see what this? Yeah, I'm sorry.
I mean, I understand where the court's coming from. I guess they could consider the other ones in 30 seconds and just go down to be not guilty. But
they're so complicated as it is.
no, I understand.
I feel terrible about giving this kind of stuff. It's just so well. Anyway, see what the instruction is telling them, that kind of cryptically. It says it tells them if after a full discussion. It says, however, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, I'm going back to a different count, you should consider whether the defendant is guilty. So it is telling them. Yeah, I just think it's kind of unclear.
I think it's very unclear. What you're saying is the law. They all agree that the elements are met and there's a privilege. You don't go any further.
Pardon me?
I believe the pattern instruction makes that clear enough. If they can unanimously agree, which includes the privilege, they're done. They don't have to go forward.
Where does it use? It says you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. So there, I don't think it's not the way a person would speak if he wanted to make things clear. And I'm not saying anyone deliberately is trying to make things unclear, but
I think one could say that about all 30-some pages of the.
Don't do that. People will find out our lawyer secret.
I think it's clear in the instructions. If the court did wish to make it clear, I would just say, just explain if you're unanimous either way on the first count, there's no need to go to the lessers.
Yeah, I think that's a good way to do it. I think I'll tell them that in any sequence, if there are lessers submitted to them, once they've discussed the highest count, if they are unanimous either way, then they're done. Does that make sense? No, Mr. Binger is having a problem with that, and let's see what he is or what he's. I don't like the way I said that either. How about this? In any count where there are multiple verdicts submitted to you, if at any point in your deliberations you are unanimous either as to both the elements, the presence or absence of the elements of the crime, and the presence or absence of the right of self-defense, you need go no further.
The reason I was shaking my head, Your Honor, is because let's take Anthony Huber's counts, for example.
Yeah.
If the jury is unanimous that he is guilty of first-degree intentional homicide, they go no further.
Right.
If they are unanimous that he's not guilty of first-degree intentional homicide, then they are instructed to consider second-degree intentional homicide.
Only if they're not satisfied that it was done in self-defense. If they, for example, if in your example, if they discussed it and said, yeah, well, sure, the elements of attempt murder are there, and then they go around the table and they say, well, we all think it's not self-defense, then guilty. If they all say we don't think it's, well, actually, if they all say we don't think it's self-defense, then it's not guilty. And what the jury is being told is if you can't agree unanimously, then consider these lessers. But I don't think it's so clear as it should be.
It says if you are not so satisfied.
I know it. Well, that's at the very end.
And I think what the court was originally proposing is telling the jury unanimous on the charge count one way or the other, then you go no further.
I like that.
That's not the law.
If you're unanimous on,
So for example,
if you're unanimous on the legal question, intentional, well, you're right, because it could be an elements issue.
the jury
Maybe the constructions committee is right. I don't know.
the jury only goes to lesser included if they are either unable to agree on the charge count or if they're unanimous not guilty on the charge count. Then they go to the lesser included. So there is no requirement that they be unanimous on the charge count to move to the lesser.
No, they shouldn't be unanimous. If they're unanimous, then they're done. That's what I'm trying to tell them, but I don't know how to say it.
But that's not true, because if they're unanimous on first-degree intentional homicide, what they're concluding at that point is that the defendant, either the elements aren't met or the defendant actually believed that deadly force was necessary. They would still then have to consider the second-degree intentional because it changes the self-defense into the objective, reasonable one. So they can be unanimous on count one. Let's take Huber, for example. They can be unanimous on the first-degree intentional homicide. They can be unanimous on that and in the defendant's favor. But they still have to then move to the second element or to the lesser included.
You might be right.
Perfect self-defense.
Pardon me?
If it's perfect self-defense, it's perfect self-defense for everything.
But they're not told to consider perfect self-defense on first-degree intentional homicide. They're specifically told.
It's fine.
Well, yeah, you're right. He's right.
They're not told to consider that until second-degree intentional homicide. The instructions, Your Honor, are the pattern instructions. I understand your point that if we had to redraft them today from scratch, maybe we could do better. But I'm sure we could. But we need to follow them, and I don't think deviation is appropriate.
I think you're right. And they are certainly correct in what they say. I just think that they're not clear. But maybe they are. I don't know. Now let's see how much damage I've done already by my last paragraph. So can you go back to what the last thing I said to the jury?
defendant is guilty of the highest degree of crime, you need not consider lesser included offenses. If you
That's-
decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense, and then that's when you stopped in mid-sentence.
So the first part was right. Did not commit the greater crime and was acting lawfully in self-defense. You know, if he was acting lawfully in self-defense, the ball game's over. Yeah. I think that's correct. Even your suggestion is seductive, Mr. Binger, but see, they're not asked to consider that. That's where I'm having the problem. There, and they even make reference to it. I think maybe I read one of the comments. They talk about how we don't have, like some states do. They have a question right off the bat: was the defendant acting lawfully in self-defense? If they answer that yes, we're all done. We've got it interlaced in all these cumbersome instructions. And now, does anyone have any objection to what I've already told the jury? Tell them what?
Just what we said. If you find perfect self-defense, you don't go on to the next count. It's over.
I understand what the term perfect self-defense means, but we haven't told the jury what that means. We're deviating from the standard instructions here. And the words perfect self-defense don't have a meaning to ordinary people, would require further definition from the court. And now we're going much further afield. I also have a problem with the wording of, if you find the defendant is justified in his self-defense, because we've instructed them on his own subjective self-defense belief, which is a defense to the first degree intentional homicide. And then we've given them the instruction on what the law considers to be objective self-defense, is what a reasonable person would think. When the wording that was just read by the Madam Court Reporter doesn't delineate between those two things. And I think, as I said, and I've repeated here several times, I think the more we deviate from these standard instructions, the more confusion it causes. Counsel has asked you to read the self-defense individually on each count. So they're already being told on each count that you are to consider the final thing is the objective self-defense. And that is if you find that, then he's not guilty. And to say across the board that you find self-defense is a defense to everything is not technically true, because there are different self-defense claims as to the different counts. So, for example, he may be justified to self-defense as to Rosenbaum, but not as to Huber. So a blanket statement that says anytime you find justified self-defense, he's not guilty, is not technically true.
Well,
So again,
it is if you're talking just about an individual count.
But I was saying blanket.
And I think what I'm going to tell them, in addition to what I've already said, is if they are discussing a count that has multiple possible verdicts.
I think that the standard instruction already spells that out, Your Honor. I agree. If we had to do it from scratch, we could do it better, but I don't think we should deviate any further, because I think it's causing confusion. What the Madam Court Reporter just read back, for example, could be construed as saying anytime with regard to any count